Hello and welcome to Rajya Sabha Television. You're watching The Big Picture with me, Frank Razan Pereira. There is no occasion to doubt the decision-making process in the procurement of 36 Rafale jets from France, the Supreme Court said on Friday, and dismissed the petitions seeking an investigation into the alleged irregularities in the 58,000 crore rupees deal. There was no substantial evidence of commercial favouritism to any private entity, the bench headed by Chief Justice Ranjan Gogoi said on the issue of an offset partner in its ruling on a batch of petitions. While one lot sought a court-monitored investigation into the deal, another asked for a direction to the CBI to register an FIR for alleged irregularities. The bench, also comprising Justices S.K. Kaul and K.M. Joseph, said it is not the job of the court to deal with the comparative details of the pricing. There has been a necessity for fighter aircraft and the country cannot remain without jets, it said. The CJI, who read out the judgment for the three-judge bench, said no reasons were found to interfere in the procurement process for the fighter jets. On this edition of The Big Picture, we will analyze the Rafale verdict. Joining me on the program today are Major General Dhruv C. Katoch, retired Director, India Foundation; Satya Prakash, Legal Editor of the Tribune; and J. Sai Deepak, Advocate of the Supreme Court. Thank you to all my guests for joining me on this edition of The Big Picture. J. Sai Deepak, I'd like to begin with you. First, let's try and put it in perspective and understand what were the observations of the Supreme Court as far as the Rafale verdict is concerned.
So, there are three sets of issues that I think the court has been concerned with. One is the aspect of price fixation. The second is the question of decision-making process. The third is the question of the Indian offset partner. On each of these aspects, the one thing that the court has asked itself is this: that the primary basis, or perhaps the sole basis for the lodging of these petitions, was a statement given by the former French president as part of an interview. And that too was only with respect to the choice of the Indian offset partner, beyond which no other comment was made even in that particular interview. So the inquiry, which started from the choice of the Indian offset partner, ultimately went to the question of the pricing itself and the rest of the technical details, when in fact even that particular interview which forms the basis of the petition does not get into any other aspect. So this is something that the court has noted. Second, that the court has also recognized the fact that when it comes to these kind of transactions, judicial scrutiny must be limited only to the aspect of decision-making process, because it obviously cannot get into the technical aspects of the transaction or the commercial aspects of the transaction, because it is limited by technical expertise when it comes to these issues. Three, the court has also asked itself whether it should get into a fishing and a roving exercise when it comes to transactions of this nature which affect national security. And I think that's an important statement, and that says that judicial restraint is being observed when it comes to these matters. The fact that such a petition was even entertained in the first place is perhaps problematic and perhaps ought to have been dismissed on day one, is something that I would certainly say. But beyond that, since the court has taken it seriously to expeditiously hear this matter and dismiss these petitions, and has now also not directed anything further with respect to the registration of the FIR, I think is fantastic. The court has also taken note of the fact that when it comes to the choice of the Indian offset partner, it was already agreed that the seller would have the option of deciding who shall be his Indian offset partner. And since both parties have denied any kind of favoritism, and this is strictly a decision that's taken between two private entities, the court does not see any kind of reason for its intervention. So I think on all three aspects, on each of the three aspects that was identified for adjudication, the court has come out with crystal clear observations, saying that there is absolutely no material at all to suggest that there is any irregularity. And the court has also said that even if there is a minor variation or deviation, that does not necessarily warrant calling into question every aspect of the contract, or a price-by-price comparison or clause-by-clause comparison for compliance.
Absolutely. Very well put there by J. Sai Deepak. Let me go across to Satya Prakash. Now, Satya Prakash, why did it have to come down to this?
Well, in the Indian system, anybody who is aggrieved can go to the court. In this case, as you mentioned in the beginning, there are two sets of petitions, one demanding CBI inquiry into the entire affairs, and the other asking for a court-monitored probe. If somebody wants to file a PIL, there is no bar on filing PIL, so people did file PIL. The only question is in this set of PILs, the kind of things they were asking for, registration of FIR against highest public authorities, and the court, as Sai has already said, the court even entertaining such petitions is problematic. But I would not say that the court entertaining, it's the court's discretion. They chose to entertain it, that's fine. But the best part is they have gone into each and every aspect of the deal. Even pricing aspect, which the government claimed that it's secret and we cannot make it public because even Parliament has not been informed about it. Even that the court forced the government to share the details with the court, and then the court, having gone into each aspect of the deal, decision making process, pricing and Indian option partner, on each aspect the court said there is no point in going for a roving inquiry into just based on conjectures or somebody's perception, and the court said it has to be dismissed. What is important is, for the first time the court summoned 3 or 4 senior most Indian Air Force officers to the court during the hearing, and then the court asked questions to them and they had to explain each and every aspect of the deal and the requirement from the Indian Air Force and how they badly needed such aircraft. And having been convinced by the Indian Air Force officers, the court went into that. One particular aspect about pricing details, though the fact is that only the court went to it and it was not shared with the rest of the petitioners. But the court has noted in the judgment that pricing details were available with the CAG, and CAG's report was scrutinized by the Public Accounts Committee. So it's not that everything is in secret. The constitutional authorities which are entitled to have a look of such things, they actually had access to that. So CAG examined it and it was placed before Public Accounts Committee also, and that's a different thing, that even thereafter not everything was placed before Parliament, because of some sensitivities involved, but it has been examined by the CAG and the CAG's report was further examined by the Public Accounts Committee.
Talking about Parliament, I'd like to touch upon it a little while later. We'll probably talk about the JPC as well, but before that let me bring in the General into the picture. General, every time there is a defense deal like this of this magnitude, it always runs into some kind of controversy or the other. Why is that so, do you think?
When we are talking about these defense deals, they are billion-dollar deals. They are massive. And
is there scope for corruption?
Actually, in any government-to-government deal, there is no scope for corruption. I mean, this is the starting point of the Rafale deal. It was a G-to-G deal. In any G-to-G deal, the very question of corruption does not arise. Now, this can arise in a case where where you're dealing with a private party, right? When you're looking at the Bofors gun, it was not a G-to-G deal. In this particular case, it was a G-to-G deal. When the Indians bought aircraft from the United States, again, it was a G-to-G deal. So, in any G-to-G deal, the one thing which we can rest assured is that the standards of the probity will be as high as 100%. So, I've got no doubts about that. So, honestly, this really shouldn't have come up. I think one of the things which has happened is people don't understand what offsets mean. Offset is simply a clause that there are a certain, you see, we have spent a lot of foreign exchange. I'll put it into layman's language, let us say this is a $1 billion deal, just for the sake of number, just $1 billion deal, and that means $1 billion we have to pay out in foreign exchange. Now, when we are looking at offsets, we say that, okay, some part of this $1 billion must come back to us. So, we tell the offset partners that you will export certain quantities to various countries so that we get back some part of our foreign exchange earnings. In very simple terms, this is an offset. Now, these offset rules have been laid out in the Defense Procurement Procedure rules. Nobody deviates from the rules, and the rule book very clearly states that the person who is selling you this is responsible for the offsets. Now, in this particular case, we were getting this equipment from Rafale. As Rafale was selling it to us, the responsibility to execute the offset contracts rests with Rafale. If they don't execute it, they will have to pay a penalty, they have to pay a price. So, logically, they will choose their partners. They will choose whomsoever they want who can best execute it. Now, I may say that A, B or C is not competent enough. Well, leave that decision to Rafale because they are accountable. I am not accountable. So, all these people who were talking, none of these people were accountable to say person A, B or C should have got it, or whether HAL or so on. That doesn't really matter. And it's got nothing to do with the deal per se, as the Apex Court has so clearly brought out, and I hope that this controversy now stands for a rest.
Okay.
But getting back to your earlier point, why? When we are talking of these very big deals, there are many in the defense, there are many players. Now, if there are 5 or 6 big players, and obviously only one of them gets it, now the other people feel aggrieved and they want to do something to see that this deal is scuttled. and the process starts all over again so they can get a chance. Unfortunately, this has been happening time and again in India, as a result of which I think, our defense procurement has been so badly delayed that I will make a very bold statement very consciously. I think we are compromising with the defense of the country. I'm making this as a very, very responsible statement, and I think all political parties should be very wary of this. It is not a question of scoring a political point over A, B or C. It doesn't really matter who's doing the procurement, but I think simply to score brownie points, if you want to scrap a deal, like if this particular deal was scrapped, I can assure you, the defense of Indian skies, especially over the Tibetan plateau, would have been compromised.
We'll come back to that in just a bit, but before that, J. Deepak, the opposition and certain political parties have been talking about how this is a classic case for a JPC. Is that really the case, or is this issue now a done deal and closed with the Supreme Court's verdict?
I have to agree with everything that the journalist said, simply because he is better informed and it comes from a voice of experience. I just wanted to add a certain logical aspect to what he was mentioning. So there's a government A, there's a government B, and there's an offset partner C. The responsibility for supplying quality aircraft falls on the government B, which is the seller. And government A says, you have to invest 50% of the amount that you're making from this particular transaction in identifying local partners for the purposes of ensuring that India gains experience in defense production. Okay, and it has some kind of technology transfer arrangements with the foreign party. So at the end of the day, can the Indian government be entering into a transaction which says, I will allow you to find out a party of my choice, and I will compromise on the quality which is being supplied because I want to favor a certain private entity, and you shall bear the penalty of the outcome? Would that be the logic? So this entire logic of this argument that this particular entity was chosen because it has a certain proximity to the dispensation in power today really doesn't make sense, because at the end of the day, a foreign government is going to be held accountable for the products which are going to be delivered, even if they are manufactured by the Indian party, which is the Indian offset manufacturer. So if you look at most of the innovation laws and also our defense procurement policy, the one thing that has been going on since 2001 is an attempt at indigenization of defense production, so that we are in a position to ensure that we are self-reliant when it comes to these technical aspects, these sensitive aspects. And just go through the timelines of the judgment. The process started immediately after Kargil in 2001, and the request was placed for 126 aircraft. That was withdrawn, and now we are at 36 aircraft. Okay, this is again, as he mentioned, interministerial consultation process. At the end of 17 years, how many aircraft are you looking at? 36 aircraft. And even that is mired in controversy. Regardless of who is in power, I think it is important that we behave a bit more responsibly. If you genuinely believe that something is fishy, and if there is something that merits some kind of interference or intervention by another organ of the state, at least have credible evidence to go to court. With this kind of nonsense that has happened, and that too surrounding elections, it really doesn't make sense. It's actually great that the Supreme Court has put an end to this nonsense before we enter 2019, which is a critical year.
Interesting that you brought up 2019 and you're calling it a critical year. It indeed is a critical year. What are the
JPC is not warranted to answer your question.
Okay, JPC is not warranted. Okay, good. Thank you for answering my question. Satya Prakash, what are the implications really going into the election year, going into 2019 as far as this verdict is concerned?
Well, had this verdict come a week or 2 weeks ago, perhaps it would have had some impact on assembly elections, and particularly Madhya Pradesh, where BJP somehow missed it by a couple of seats, or
7 seats.
4, no, not 7, 110 or 9 they got, so 6 or 7 seats.
Yeah.
So I'm saying it would have had some impact on assembly election, and certainly it will have some kind of bearing on the next election, because had it been, supposing the court had given a verdict of not of this kind, or court had said something is fishy in that, supposing had the court said something of that sort, it would have certainly had some kind of negative impact on the outcome for the ruling dispensation. But having been having been cleared by the Supreme Court, this deal is going to have no bearing, no negative impact on the BJP or the NDA, because for them to go to the electorate with this kind of verdict and say that, look, here is the deal which the Supreme Court has put a seal of approval. So whatever the opposition might say, but certainly it will not have any kind of bearing. So far as JPC is concerned, JPC, we have had several JPCs. We had JPC on Bofors, on even 2G. It's a political thing mostly, because whatever happens in JPC, most of the political parties, their representative, they behave in a partisan manner. I'm sorry to, it's not like what happens in the US in congressional hearings. Here it's a completely different thing. But I'm afraid the Congress would not be satisfied by the Supreme Court verdict. During the day, we have heard several Congress spokespersons saying something, including Mr. Anand Sharma. So they are not going to accept this verdict, and they are raising their voice for JPC. They are demanding JPC. I'm not saying they are not entitled to, but having this kind of verdict from the Supreme Court, which has given all clear for this deal, thereafter, if you demand it, I'm afraid they would be, putting their credibility at risk, because they will be indirectly questioning the Supreme Court verdict, which has
not given them any scope really to...
Yes, because on all three counts, they have said they have given clean chit to the deal, and further, they have also highlighted the fact that India cannot remain underprepared or unprepared for any eventuality.
Absolutely. I'm going to take that point forward. India can't be unprepared for an eventuality. That's something that you touched upon during your opening remark as well, General. How important was it, or is it, for this deal for us to go through and get these two squadrons of the Rafale jets?
I think, in my personal view, this is one of the most vital deals for the defense of India. People don't realize that when we are looking at, I'm not saying that we are going to go to war with any other country. That's not the point at all. The point is, so long as you are prepared, there is no war. You only go to war if you have become weak and the other party thinks they can get away with it, right? So this, when you're looking at the Rafale and you're looking at it as a deterrent, I think this was a very strong deterrent to maintain peace. So I want to shift the whole argument around. Rafale is not required to wage war. Rafale is required to maintain peace. And I think to have a squadron of Rafale available for our eastern borders, which is in a position to operate over the Tibetan plateau, is a vital component of India's defense. Without it, our defense would have been very seriously compromised. I'm using this statement again very deliberately, because it is something which is so vital to the interest of India's defense. It is not simply a question of what the Air Force says. This is what the country needs. And the Air Force has been saying it for the past so many years. The Air Chief has come out openly. I mean, for the first time I'm seeing a dignitary as senior as the Air Chief is going to various forums and explaining the position to the public. He's also had the media there and trying to explain it to them. I've heard the Air Chief on 3 or 4 occasions. And why have we reduced ourselves to the situation by which we have to question the Chief of the Air Staff? We have to question the marshals, the air marshals, and every single person of the Indian Air Force who has spent his lifetime studying it. And in this particular case, more than a decade of study has gone into trying to tell the people, for God's sake, we need it, and we need it yesterday, not today. We need it yesterday. We're already late. It should have been done. This should have been purchased in the UPA 2. I'm afraid that by not clinching the deal in UPA 2, they have compromised with national security.
All right. Closing comments now from all my guests, starting first with you, J. Deepak. Should all campaigns against the Rafale deal end now? And that having been said, are there any legal options remaining as far as the opposition is concerned left to exercise?
They could always go for a review petition, and I would think that that's only an option available on the book. But most importantly, this is one of the matters where I would have actually expected the Supreme Court to have the hearings live streamed, because I think it's important for the people to see what kind of arguments are being made and what has been the reaction of the bench. What are the questions that were put to the Indian officers? Most importantly, even if there is a JPC, I think we must start making it a practice, just like congressional hearings, that it should all be held in open and the people should have an access to what is being said. Because the one thing that I'm asking myself is, if there is a petition that's filed by a former finance minister and a former investment minister, what is it that they were actually thinking when they filed this particular petition asking for registration of the FIR? That's something that you have to ask yourself. I really don't know what was going on. Where effectively on such a critical issue, as he rightly said, one of your service staff, your service chief, has had to go from pillar to post trying to explain why this is needed, particularly when its criticality is well known. I think it's shameful that we have actually reduced our service chiefs to this extent, where they have to justify every sensitive transaction. When it comes to defense, at the very least that we must do is realize that we are in a position to shout and crow because India exists, and therefore our territorial integrity cannot be compromised upon for political purposes and exigencies. If that is a red line that we are not willing to observe, then I don't know what to call ourselves.
All right, General, you did mention we have a rule book really as far as defense procurement is concerned. When the rule book is followed, why do we need anything else?
No, honestly, we don't need anything else, because here, this was the G2G deal and they went as per the book. I have personally interacted earlier with the former Defence Minister, Shri Manohar Parrikar, and presently also with the present Defence Minister. And I'm absolutely convinced, even with my interaction with various officers of the Indian Air Force, from the chief downwards, that this deal is one of the best deals which India could have ever got. And it is something which we should be proud of, instead of actually making something which is so good to make it look evil. I think we should put the politics out of this here. National interest is being compromised. Your defense is being compromised.
And as far as the rule book is concerned, General, what is the process that is to be followed really?
No, the DPP has laid down very, very clear. It is a defense procurement procedure, and it is an open public. This book is available in the public domain. In this DPP, it has very clearly been stated that the offset partner will be chosen by the supplier.
Exactly.
Now, if the offset partner has to be chosen by the supplier, and if the supplier is responsible for it, you see, the question is of accountability. If I have got to, one of the reasons why I think I must inform, just an off-the-cuff thing, but I think I must inform, one of the reasons why this deal didn't go through in the UPA 2 was because the then Defence Minister, Mr. Antony, put a remark on file to say that the aircraft which will be manufactured by HAL will be guaranteed by Rafale. Now, if HAL is going to manufacture the aircraft, obviously Rafale is not going to guarantee it. So this deal died. So we cannot have. But in the other case, as far as the offsets are concerned, it is the responsibility of the person, in this particular case Rafale. So once they are responsible for it, it's a different issue. So I think the DPP is a very good document. I think we need to further refine it, not in the sense of, not for probity, but to really streamline it and make it a faster system. Because our defense system, our procurement system is still very slow, and every time we delay matters by a year or 2 years, we lose hundreds and thousands of crores. So we are a poor country, we can't afford that. And but more importantly, as what my colleague said earlier, and I totally agree with him, I think the time has come for indigenization. And we need to manufacture our own systems in-house. We need to ensure that the DRDO and our defense ordnance factories actually perform the way they were mandated to do. And we should go ahead with that.
And
just
yes.
Those who are asking this question as to why HAL was not chosen as the Indian offset partner must just read one judgment passed by the Delhi High Court Division Bench by Justice Ravindra Bhatt. Sanjeet Kaila versus Union of India, where this was a pilot of a MiG aircraft. And you will see what is the report of inquiry, what it says with respect to the quality of manufacturing. And that matter is currently before the Supreme Court. That is the status of the ability of HAL to manufacture. Therefore, if a foreign government chooses not to interact with HAL when it comes to choosing who it shall work with as an Indian offset partner, then HAL cannot use a political party, or no political party should use HAL to fire its political arrows. Because then at the end of the day, we are sacrificing national security at the expense of indigenization. You need to strike a balance between both imperatives.
All right. Satya Prakash, close the show for us with your concluding remarks.
Well, so far as politics over this particular deal is concerned, it should ideally end, but I am afraid it would not. The second is, in the last couple of years, almost every institution has been politicized and brought into some kind of disrepute on allegations, counter allegations, be it election commission, be it judiciary, every. At least defense forces should be spared, and political parties should, at least some kind of consensus should be reached about defense forces, that at least they would not be brought into any kind of controversy, because after all they are dying for our defense. So they're
safeguarding us.
Yes, safeguarding. So spare them, and national security should be beyond political controversies.
I hope those who are watching and those who are listening get that point really, and ensure that national security should be of utmost importance and right on top of everyone's agenda. That's what the other panelists are saying here on The Big Picture as well. I'd like to thank all of you for joining me on the program and putting things into perspective for us. That's it on this edition of The Big Picture. See you again next time.